Mr. Beat presents Supreme Court Briefs.
Millington, Tennessee, 1961. Charles Baker, a member of the Millington Board of Aldermen and former mayor of the town, was frustrated. For decades, he and his fellow Shelby County residents had felt helpless as they got less and less government assistance and less representation in government. You see, Shelby County is part of the Memphis metropolitan area, and its population had dramatically grown since 1901. Tennessee, and the entire country overall, had become much more urban in that time span. Wait, why did I randomly bring up the year 1901? Well, that was the year the Tennessee General Assembly had last redrawn legislative and congressional districts. Now, the Tennessee State Constitution said all districts had to be redrawn every 10 years, after the census, to make it so that every district had as equal number of people living in it as possible. Well, as I said earlier, in the 50 years since the Tennessee General Assembly last redrew districts, the population had shifted in a way that Shelby County had about 10 times as many residents as some of the rural districts of the state. The Memphis, Nashville, and Knoxville metropolitan areas had 63% of the population of the state, but only 13 of the 33 state Senate seats. In other words, the votes of rural citizens were way overrepresented compared to those of urban citizens of the state. Baker wasn't the only one mad about it, bruh. After the Tennessee government refused to redraw districts again after the 1960 census results, he and a bunch of people sued them. Well, specifically, they sued Joe Carr, a state official in charge of Tennessee elections. Baker argued that the votes of Tennesseans who lived in urban areas didn't count nearly as much as the votes of Tennesseans who lived in rural areas. Simply put, the Tennessee legislature didn't reflect the state's population, and this went against the Equal Protection Clause of the 14th Amendment of the Constitution, and dang it, every vote should be counted equally. One person, one vote, and stuff. Well, Carr was like, heh, because he had precedent on his side. You see, the Supreme Court had historically not got involved with what state governments did when it came to, quote, political questions. Political questions are ones that involve, politics, or how power is distributed. And the court had consistently tried to stay as apolitical as possible, meaning if a case was too political, they didn't want to touch it. But come on, almost everything is political, for crying out loud. Anyway, the Supreme Court had brought up what became known as the political question doctrine in several cases before 1961. The most relevant case to the Tennessee government's shenanigans was Coal Grove v. Green, decided in 1946. In it, the Supreme Court ruled that it couldn't step in after the Illinois government hadn't redrawn its congressional districts since 1901, which led to rural votes counting way more than urban votes. And I call not drawing up new districts shenanigans, not only since it went against the Tennessee Constitution, but in the context of the Civil Rights Movement. You see, the Tennessee government knew what it was doing. It was giving more power to the rural parts of the state because those parts were more white. And it was giving less power to the urban parts of the state, which had more people of color. Well, the U.S. District Court for the Middle District of Tennessee dismissed the lawsuit, saying it couldn't do anything because it was a political question and citing the Coal Grove case. So Baker appealed to the Supreme Court, and boy were they nervous to take it on because they knew whatever they decided would be a big freaking deal. But they agreed to anyway, hearing oral arguments on April 19th and 20th, 1961. That's right, 2 days. And apparently that wasn't long enough because the justices just couldn't settle on an answer to the question, should we, as the Supreme Court, have the power to step in over questions of legislative apportionment? They argued back and forth with Justices Hugo Black, William Douglas, Earl Warren, and William Brennan on the yes side, and Felix Frankfurter, John Harlan, and Tom Clark on the no side. Justices Potter Stewart and Charles Charles Evans Whitaker were the swing votes. They just didn't know what side to choose, man. They did know that if they said yes, the implications would be huge. The pressure was too much for Whitaker, so he disappeared. Seriously. He left Washington, D.C. and retreated to a cabin in a remote Michigan forest.
But solitude
Didn't improve his health much, and he eventually suffered a nervous breakdown and apparently became suicidal. Whitaker did return to the court when they reconvened in the fall. They heard more oral arguments on October 9th. Flash forward to March 1962, and Frankfurter had convinced Whitaker to join the no side. However, by that time, Whitaker's mental health was in such poor shape that he checked into Walter Reed Hospital. He would never return to the court and officially retired from it a few days later. And here's the thing, as it turns out, they didn't even need Whitaker's vote since not only Potter Stewart but also Tom Clark had shifted to the yes side. On March 26th, the court had announced that it had sided with Baker. It was 6-2 since Whitaker's name was removed from the dissenting opinions. So yeah, the court ruled that they did have the authority to rule on questions of legislative reapportionment. This, along with other future cases, created the basis for the one person, one vote doctrine, which said that states had to at least try their very best to divide up their representatives in a way that represented all citizens equally so that no votes counted any more or less than any other vote. In other words, the 14th Amendment's Equal Protection Clause did imply that every vote ought to count equally. Following this decision and other future decisions, most states had to redraw up their districts to make sure that rural votes didn't count more than urban votes. While this did lead to more equal representation, one unintended consequence of this decision was it leading to more gerrymandering, which is arguably a bigger problem today than it ever has been. Although the court did address racial gerrymandering in the case Shaw v. Reno. Yes, I have a video about that case. Check it out. And finally, this case made it so that the court would likely be much more busy from now on. Before this decision, the court avoided getting involved with political questions. Now, it was clear, oh, they getting involved all right. Although Justice Brennan did identify 6 situations in which the court would not look at political questions, and here they are. Yeah, I'm not reading that. You can pause this and read it if you want to. But yeah, basically from now on, the court would jump in on some kinds of politics in some cases, all right? Baker v. Carr is one of the most important Supreme Court cases in American history. It really opened up the floodgates. Although the court has always been at least somewhat political, I'd argue this case made it much more political. I'd also argue that no Supreme Court case in American history has ever tested our justices more so than this case. I mean, it led to one justice having a nervous breakdown, for crying out loud. I'll see you for the next Supreme Court case, jury. This video is once again sponsored by Brilliant. As a teacher, I found that the best way to learn is interactively, and Brilliant is an amazing tool for learning STEM interactively. But it is also good at personalizing learning for you. Learn at your own pace, learn on the go, learn something new. Brilliant puzzles you, surprises you, and expands your understanding of the modern world. The course I really love lately is called Everyday Math. I never thought I'd say this, but the course has helped me not only appreciate but enjoy doing math problems because it makes it so easy to learn. To get started for free, go to brilliant.org/MrBeats or just click on the link in the description of this video. Also, the first 200 people to do so will get 20% off of Brilliant's annual premium subscription. This was another landmark Supreme Court case, which just means it was freaking important, and I can't believe I just now covered it because I should have covered it a long time ago, really. So what other landmark cases should I cover for this series? Reynolds v. Sims, anyone? Let me know in the comments below. Also, there's a good chance that you're watching this in school right now, so you really ought to turn to your teacher right now and tell them they're doing a wonderful job. It's not easy being a teacher. Trust me.